Morning.
The only case on the 10:15 docket is 14-742. Mr. Angus, you are the only one here on this case this morning. Do you understand that you have 15 minutes to present your argument to us?
I was going to see if it's possible for me to do an ex parte for extension of time, since how the plaintiff has not shown up or filed a brief at all.
I'm sorry, what were you saying?
I'd like to know if I could do a ex parte motion and get an extension of time.
No, your case is scheduled for today, so today is when you will have to present your argument to us.
Okay. Just tell me when to go.
All right, please start now, and I will keep time for you.
All right. What we're doing here is we're looking at disestablishment with no jurisdiction. Bias, partial, denial of protected parental rights, failure to provide counsel to an indigent litigant as the state initiates disestablishment of paternity, parental alienation, denial of visitation, ignoring fundamental rights to parent, malicious prosecution, state-assisted malicious prosecution, state willfully allowed a parent-child relationship to be destroyed, state-assisted discrimination, child abuse, state-assisted child abuse, extreme cruelty, false imprisonment of a person, cruel and unusual punishment, and ignoring actual reasons for divorce to favor the other party. I've started off with some quickies here. The first one is denial of fundamental right to parent, best interests of the children. It's pretty much open and shut. According to Ohio law, RC 3109.04 F2B, 3109.04 F1I, and 3109.05.1 D and 13. These are actually combined here, so I'll just go through them. Parent more likely to honor and felicitate and reschedule court-approved parenting time, right or visitation, companionship rights. And I'd like to let the record show that that did say companionship rights. Whether the residential parent or the parent or one parent subject to shared parenting decree has continuously and willfully denied the other parent the right, again it's saying the right to parent time in accordance with an order of the court. The most damning piece of evidence I got for this, which would be from the divorce decree, page 13, where the judge states under 9, she has continuously and willfully denied him time with Evelyn in violation of the court's order. Chat's pretty much open and shut. Rights were violated. Nobody cared. The law states that people should have been caring by a lot. That is what the best interests of children actually are. Companionship, being able to share love, affection, and companionship with the other child. But it does show something else that the court has been willfully ignoring for way too long and be getting away with constantly. It shows the plaintiff is guilty of the following. Denial of fundamental rights to the other parent, as stated above. Gross neglect, as the parent ignores the best interest factor and the law above. Extreme cruelty, as the plaintiff ignores the best interest factors and the law above. Any gross neglect of duty, we all know that the plaintiff was having an affair. She abandoned me to pursue that affair. Keeping the children from visits and lying about it. She committed perjury. The way the evidence to show all this to be true, transcripts of June 14th, 2013 of the defendant Taylor. The question I asked was, how many times did she go to the visits with her father? He said none because she refused. And transcripts of May 8, 2013, the plaintiff is answering. Same basic question. Answer, Evelyn was actually in the van when bringing all of the children to the building for the visits. She chose not to come in. This is completely shattered by anybody willing to do what the law says, and that's to review evidence. And the evidence was in the form of the Guardian ad Litem report, page 12. The parent more likely to honor parenting time rights. It is generally unclear at this time whether both or either parent will honor parenting rights. However, since the termination, Evelyn Angus is not Larry Angus's biological daughter. Sarah has refused to take Evelyn to any ranch visits. So now that we show all those completely wrong, can any of the appellate judges show anywhere in the divorce decree where it says the plaintiff is guilty for denying the other parent rights, where it says she is guilty of gross neglect and extreme cruelty? Any place in there whatsoever for the plaintiff is what I'm looking for, because I don't believe it exists at all. The only thing that the plaintiff was caught guilty of is having an affair. She had another man's baby while she was litigating for divorce. So the absence of the gross neglect, the extreme cruelty, the denial of rights, the denial of fundamental rights to parent, the divorce decree, it has no grounds. It should be omitted completely. That right there destroys everything Ohio swears to protect, and that would be the best interest of children. When you go against that, you have no right to make any kind of an answer, especially when that answer is one-sided. As we know, like I just said, in the divorce decree, it says nothing about gross neglect, extreme cruelty. Fundamental rights aren't even listed. There's actually plenty of excuses for the plaintiff on the denial of fundamental rights. Absolutely none for Larry, which is me. So I'll be talking in third person, and every now and then, instead of saying the trial court, I'll more than likely say the judge or Gill or somebody. Just bear with me, please. I objected to the magistrate's decision saying that the plaintiff did not contend. And when I did so, it was denied. I also asked the magistrate to recuse because I felt she wasn't properly doing her job, and that is those two rules to protect rights. It is a judge's duty as a judge, regardless if I'm aware of my rights being violated or not, a judge should be able to figure out somebody's rights being violated and speak up and not keep it a secret, and then take those decisions and then use it on the other party. That was uncalled for. Completely unfair. I'm sorry. As we could see from when did visits actually start? Well, with Jerry, Larry, and Abby, it did not go for a month, 2 months, 3 months, 4 months. It took 6 months for the court to even try and get those started. Unfortunately, the Supreme Court says loss of First Amendment freedoms, even for a minimal period of time, unsequentially constitute irreparable injury. That was Elrod and Burns, 96 SCT 2673 Boris 27 US 34 7 1976. Now, when did the visit start? That included Evelyn, and I'll remind the appellate court that at this time the establishment of paternity did not take place. Did it start the first month? Nope. 6 months later? Nope. Year later? No. Did it start a year and 10 months later? No. As admitted by the judge, she willfully denied him time in violation with the court's temporary orders. So there we have another scapegoat by the trial court trying to excuse the plaintiff and her wrongdoings. This can't be argued. There's absolutely no visit with Evelyn whatsoever. Just because the court disestablished paternity doesn't excuse the court from breaking the law, upholding rights. That is an oath. The oath is to protect the Constitution, all rights contained in there. Without doing so, it just shattered every right that I had. There was no fair trial to go on whatsoever. With the judge admitting, though, however, that she has continued and willfully denied him time with Evelyn in violation of court's temporary orders, it showed several things. It showed my objection to the magistrate rule should have been granted. My motion for the magistrate to recuse because of that, it should have been granted. My motion for the judge to recuse for failure to uphold those laws, they should have been granted. Instead, everybody chose to pick on my ADHD and bring up arguments saying that I am too incompetent to handle my children. I entered a Rule 60B that completely shattered all of those beliefs. In the Rule 60B, and I'll just show you a quick one. Here's me. Do you know I need to have the bailiff bring this up? It's on the record.
If it's in the record, we will review the record when we're looking
Okay,
at
it's the Rule 60B, How the Truth Sucks. Shows me putting toys together for the kids on Christmas. Shows me sitting there playing with the kids and the pregnant plaintiff before she had Abigail, which was in 2009. It shows me afterwards holding on to Abigail, cuddling. It shows me cuddling every damn child that I had. It shows me playing with the kids. That would be giving them love, affection, companionship from one parent to the other, to the children. So, what we got here is another error in the law. You got 3 motions that were guaranteed by the rules to be proven. And when they couldn't, they just dismissed them. And I constantly see one thing that's really annoying the hell out of me on...
Mr. Angus, you have to keep your language...
Oh, okay. I got you. I'm sorry. I'm just...
You can't use those words.
Okay. Something that's really annoying me is at the end of every answer, every decision I ever got is not well taken. Not well taken to me means somebody is thinking with their beliefs and not the law. And with these 3 motions, motion against the magistrate's decision, motion for her to recuse, and the motion for the judge to leave, because of the visitations violations, that shows that nothing at that point was valid. And not a thing. And I think I moved it. Yeah. So, the Supreme Court, they say any judge who does not comply with the oath of the Constitution of the United States swears against the Constitution and engages in acts in violation of the supreme law of the land. That's pretty much all that needs to be said on that, because that shows that all 3 of those motions and the visitation violations, nothing upheld any of my rights whatsoever, and that includes counsel. From day one, I was denied counsel, regardless. That case law for the Supreme Court, that's Cooper versus Aaron, 358 U.S. 178 SCT 1401 1958. But so we got an invalid decision. We got judges making decrees, even though they completely went against everything Ohio stands for. That's the Ohio Revised Code. It's the law. If I'm expected to follow the law, I expect every judge, magistrate, and everybody involved in it to do the exact same thing, and that is to follow the law. And if they can't follow the law, then they need to excuse themselves. Instead of sticking around and disestablishing paternity. Especially when there is no time. You have...
Mr. Angus, you have used your 15 minutes.
Oh, did I?
At
Okay,
this
I'm
point.
sorry.
So you will receive a notice of our decision. You will receive it in writing. You will receive a copy of our decision in writing.
In writing?
Yes.
Okay.
Thank you
much.
Thank you. And this concludes the 10:15 docket.
All right.